Right, so Israel just got the kind of judgment you can't spin, veto, or blow away. The International Court of Justice has ruled that its blockade of Gaza isn't a security measure, it's a breach of humanitarian law, a textbook violation of the duties every occupying power signs up to. In one afternoon, the world's top judges dismantled 2 decades of excuses. No, Gaza isn't self-governing, and no, UNRWA isn't a front for Hamas. Even the courtroom decorum couldn't hide the scale of the spanking Israel got delivered to it, destroyed on every single count. Within hours, Israel of course vowed to ignore the decision, confirming exactly why it was issued. This wasn't a war crimes charge this time, though. It was worse. It was far worse. A formal declaration that Israel has stepped outside the law it claims to live by, and by declaring they are ignoring the ruling, they have now officially declared themselves to be a rogue state. Right, so yesterday the International Court of Justice issued a judgment, didn't it? Of course it did. That ended decades of ambiguity, let's call it, on Israel's part. In a packed courtroom in The Hague, the ICJ President Yuji Iwasawa read the opinion aloud. Israel, as the occupying power, must ensure the provision of food, water, fuel and medical care to civilians in Gaza, and must allow UN agencies, including UNRWA, to operate freely. That line changed everything. It confirmed that the Gaza Strip remains under Israeli occupation, and that the siege imposed since 2023 violates the 4th Geneva Convention. The court ruled that starvation of civilians is illegal under any circumstance, and that Israel's 2-year blockade, combined with the ban on UNRWA, constitutes a breach of international humanitarian law. The court also dismissed the centrepiece of Israel's public defence, the claim that UNRWA staff were infiltrated by Hamas. The judges found no credible evidence for that whatsoever. Israel lied through its teeth. Well, colour me surprised. But the court was having none of it. By rooting its language in treaty clauses rather than in politics, the ICJ left no room for error. There was no escape route for Israel left here. Gaza's deprivation was not unintended hardship, it was the direct result of Israeli policy. More than 2,000 Palestinians have already died near aid distribution points between March and May of this year, while convoys were being blocked. The legacy of the risibly called Gaza Humanitarian Foundation. 360 UN staff were killed in the same period. These numbers were drawn from UN and ICRC field data already on record. The ruling, therefore, reflected fact and not sentiment. The advisory opinion runs to over 100 pages, as these things often have a tendency to do, but its conclusions fit onto one. Israel is the occupying power. It has failed to meet its humanitarian obligations. Its blockade and restrictions violate Article 55 and 56 of the 4th Geneva Convention. Its use of starvation breaches Article 54 of Additional Protocol 1. Its allegations against UNRWA lack evidence. 40 states and international organisations presented submissions. Only 2, the United States and Hungary, opposed the prevailing view. That near unanimity makes the ruling the most isolating legal defeat Israel has ever faced. The decision also activates another body of law now, Articles 40 and 41 of the Articles on State Responsibility. Other governments now have a duty not to recognise or assist an unlawful situation and to cooperate to end it. The legal burden has now shifted outwards. Complicity now carries its own liability. For those states insistent on assisting Israel, the legal consequences for them just got a whole lot bigger. And this is why this ruling cuts deeper than, say, the 2004 Wall opinion, or indeed the 2024 Genocide Prevention Order off the back of South Africa's case, which is the one many of us might have considered up until now to be the most significant. Those earlier cases defined principles. This one establishes evidence. It names the blockade, counts the dead, identifies obstruction as a deliberate act. The paper trail becomes a legal fuse here now. Within hours, of course, an Israeli official told Cannes News, however, that UNRWA will no longer set foot in Gaza. It was an open declaration, therefore, of non-compliance. Baby spitting the dummy again. Cue the toddler tantrums, all made on national TV. The same official repeated the discredited claim that UN agencies were controlled by Hamas and said Washington had been notified. That single quote converted a legal defeat into a diplomatic crisis. Israel had not only lost the case, it had chosen to defy the verdict. In law, that matters. Non-compliance extends the breach and invites countermeasures by other states. In politics, it forces allies to decide whether they will join Israel in violating international law, because they've now blatantly said that's exactly what they're going to do. Norway was the country that initiated this request for this opinion all the way back in 2023. Hours after the judgment, their Foreign Minister Espen Barth Eide announced that Oslo would take it to the UN General Assembly now. The draft resolution, now circulating in New York, demands that Israel lift its restrictions, restore UNRWA's mandate, and permit full humanitarian access. It also instructs the UN Secretary-General to report within 60 days on compliance. If the Security Council blocks enforcement, of course the US will veto it, there's no if really, is there? The General Assembly can invoke its Uniting for Peace procedure. They did it for the Suez Crisis of 1956. They did it against apartheid South Africa. Though, of course, the current UN Secretary-General Antonio Guterres has been avoiding this measure like the plague, it seems. Under that mechanism, however, no state has a veto. A vote showing 140 countries in favour and just a handful opposing would formalise Israel's isolation in international law. The UN needs to grow a spine at last and do this. The impact of this judgment, however, unfolds in layers. It has layers like onions and, well, ogres if you've watched Shrek, apparently. First, it erases the disengagement myth. Israel's 2005 withdrawal from settlements did not end control of Gaza's airspace, sea access and borders. The court's confirmation of continuing occupation means every act inside the Strip falls under occupation law. Second, it invalidates Israel's attempts to substitute a national Gaza humanitarian foundation for UN operations. The court found that body inadequate and unlawful, which does sound like an understatement given what we've seen come out of that, but it removes any claim that Israel could self-certify compliance. Third, it completely vindicated UNRWA. Donor states that froze funding on the basis of Israeli allegations must now acknowledge that the allegations were unproven. Their suspension decisions themselves become part of the legal problem now. And fourth, it internationalises responsibility. Other states are now legally obliged to avoid enabling the blockade. That requirement feeds directly into export control law in Europe, in North America and Australia. And finally, it isolates Israel's chief protector. With only the United States and Hungary defending its position, Washington now carries the entire reputational weight of defending an indefensible act. That'll come crashing down on Trump's shoulders harder than the East Wing of the White House just did. The ICJ's analysis rests on field data, not rhetoric. The United Nations and the ICRC recorded that calorie availability per person in Gaza fell far below emergency thresholds. Hospitals reported deaths from dehydration and untreated infection. These are the objective indicators by which humanitarian lawyers identify starvation as a weapon. By citing them directly, the court converted a moral accusation into a legal classification. Humanitarian crisis is a journalistic phrase. Starvation as a method of warfare is a crime. The distinction is the difference between empathy and evidence. Israel's official line, security necessity, could not survive scrutiny either. The court documented that between March and May of this year, a total blockade was in place and that the restriction of supplies was a policy decision, not a battlefield necessity. It recalled that UN premises and staff are protected under the 1946 Convention on the Privileges and Immunities of the United Nations, and that this protection was breached. Once these facts were entered into the record, the logic of self-defence just collapses. A state cannot claim security while withholding food from civilians it occupies. For donors, this finding also removes the fig leaf of ambiguity they might have been clinging on to cover their own dignity. Continuing to cut UNRWA funding, as some nations have, or made it conditional, now sustains an unlawful condition. Only one judge dissented, and for those familiar with the ICJ makeup in relation to Israel, to any particular degree in fact, in any case, I wonder if you might be able to guess who it was. Yes, it was she who has openly stated that the Lord is counting on me to stand on the side of Israel. Uganda's representative, even though they've distanced themselves from her as well, Judge Julia Sebatinde. The International Commission of Jurists has requested an investigation into her impartiality. The episode turned what could have been a unanimous routing for Israel into her routine dissent and another example of her seemingly self-proclaimed bias. The result was nevertheless striking her aside. 14 judges from every region concurred on the law. The sole dissenter just undermined herself again. Governments across the globe hailed the opinion as vindication. South Africa, Malaysia, Chile, Ireland, they all declared support for Norway's resolution. The Arab League called it a watershed. Western responses were cautious but telling. Washington called the decision non-binding. London promised to study it. Brussels expressed concern. Yet legal departments within those governments must immediately begin reviewing arms licenses and export risk frameworks in light of how the law has applied to them. It just got broader. Once a judgment of breach exists, ignoring it carries its own liability. Banks and insurers have noticed too. A country formally declared in violation of humanitarian law, well, it becomes a bit of a compliance hazard. That's not good for business. Risk managers treat such rulings as triggers for reviews, raising borrowing costs and deterring investment. So the market's language for accountability is quiet but effective. And for all of Israel's throwing of the toys out of its pram, they now face another economic shock off the back of this. And the pattern's a familiar one. In 1971, the ICJ ruled South Africa's occupation of Namibia illegal. Western governments just dismissed it. 15 years later, though, that same opinion underpinned the sanctions that helped end apartheid, though. Israel now occupies the same legal position, an international pariah whose immunity is eroding case by case. Each act of defiance just adds weight to the record. The law can be patient. People can't afford to be, but the law is patient. It accumulates evidence until enforcement becomes a matter of timing and not argument. So shortly after the verdict, more than 450 Jewish academics, writers and artists signed an open letter demanding sanctions on Israel now. They accused Israel of war crimes and genocide, called for an arms embargo and asset freezes, and urged governments to distinguish between anti-Semitism and legitimate criticism. And of course, this intervention, their statement matters because it dismantles the constant Israeli reflex defense that opposition to Israeli policy is steeped in racism. Many in Jewish communities have been put in danger by Israeli conflation of Judaism and anti-Semitism. It is so important that as many members of the global Jewry keep on speaking out on this. Norway's draft resolution will reach the General Assembly before the end of the year. Once adopted, the Secretary-General must report within 60 days on Israel's compliance. If non-compliance persists, and I suspect most of us assume it will, an emergency special session under Uniting for Peace can recommend collective measures. It has to happen. Such recommendations are not binding, but they do give political and legal cover for states to impose sanctions or suspend trade, so it would be incumbent upon all of us as ordinary citizens of these states to apply the pressure. Simultaneously, the International Criminal Court, the ICC, can incorporate the ICJ's factual findings into its ongoing investigation into crimes in the occupied territories. The court in The Hague now holds both the factual and the legal record to proceed with, after all. The confrontation is no longer between Israel and UN agencies. It's between Israel and the international legal order now. Article 94 of the UN Charter requires members to comply with ICJ decisions. Defiance, therefore, breaches the Charter itself. If this violation passes without consequence now, the United Nations will have admitted that its highest court can be ignored by the powerful and obeyed only by the weak, and the functional collapse of international law will basically be complete at that point, won't it? Legal accountability produces financial friction. Civil society groups in Britain, Germany and Canada have filed or prepared court challenges arguing that continued arms exports now contravene domestic law. Parliaments have debated suspensions. Export regulators are reviewing licenses. No embargo has been declared, but the bureaucratic tempo has changed because it's had to. Decisions take longer. Risk assessments expand. That delay is the market's translation of moral pressure. The ICJ's opinions strips Israel's administration in Gaza of any legal legitimacy. Under occupation law, authority depends on meeting humanitarian duties. Once those duties are violated, the administration becomes unlawful. It is that simple. Every further act, therefore, of settlement expansion, of border closure, airstrikes on civilian infrastructure, it all extends the chain of illegality. The ruling freezes that status in the record. It will appear in every future case file and every future negotiation. The initiative for this case came not from Washington, not from Brussels, but from the likes of Pretoria and Kuala Lumpur and Oslo. The Global South drove the process and won here. The geography of legal authority has very much changed. For decades, Western governments claimed guardianship of international law, but this ruling demonstrates that its defence now rests with those who were once disproportionately marginalised by it. For the United States and Europe, their foreign policy rhetoric depends on the rule of law, yet they now shield a state found to be repeatedly violating it. Now, to ignore the ruling is to prove that rules-based order means selective obedience, yet many of us, especially when it comes to the Trump administration, would expect nothing else. The thing with these ICJ rulings is that each one we get, and this is now the third in relation to Israel and Gaza since the genocide began in October of 2023, becomes a foundation for the next. Back in 2004, the Wall opinion led to national court cases on settlement goods. The 2025 Gaza opinion will underpin future sanctions and prosecutions. Law accumulates through documentation until politics eventually catches up. This ruling defines three things, though, that can no longer be argued no matter how much Israel wails about it. It defines starvation, blockade and obstruction of aid as illegal acts by a recognised state. It defines UNRWA as an indispensable UN agency under protection of international law and innocent of Israeli accusation, and it defines the obligations of all other states to end their material support for the blockade through ongoing support for Israel. Definitions like these are permanent. They outlast governments. The ICJ's newest opinion is the most comprehensive judicial condemnation of Israeli policy since 1948. It is that big. It records violations of humanitarian law, invalidates Israel's excuses, and imposes obligations on every other government in relation to it. Israel's immediate response, defiance, confirms the finding. The issue now is enforcement. Whether the international community acts will determine if international law still functions as law, or whether it has been rendered meaningless as Israeli interests end up prioritised over it. If the ruling is ignored, the promises of accountability and of never again made after 1945 will die with it. If it is enforced, however slowly, it will still mark the moment when the law finally outlasted Israel's impunity. So now the question we're left with is a very simple one, isn't it? Who will obey the court, and who will join Israel in defying it and becoming criminals themselves? Speaking of court cases, though, this isn't even the first massive legal blow to batter Israel this week, as a massive new 120-page dossier has been handed to the ICC now, which the ICJ ruling will now cast an even greater light over, already causing Israel to panic as it was to begin with. So get all the details of that story in this video recommendation here as your suggested next watch. Please do also hit like, share and subscribe if you haven't done so already, so as to ensure you don't miss out on all new daily content, as well as spreading the word and helping to support the channel at the same time, which is very much appreciated, holding power to account for ordinary working class people. I'll hopefully catch you on the next vid. Cheers, folks.